Welcome to Cordell Cordell's Men's Divorce Podcast, bringing you information for guys before, during, and after divorce, and everything related to family law. This podcast is not to be taken as legal advice, and no attorney-client relationship is established.
Hello, and welcome to the Men's Divorce Podcast. I'm Kim Gray. I am a Cordell Cordell management partner. I work out of the St. Louis office, and I've been here for 15 years now. I'm here today with Patrick Kelly. Patrick, why don't you go ahead and introduce yourself?
Hi, I'm a litigation attorney, a lead litigator in the Dallas office of Cordell Cordell. I've been with Cordell for almost 8 years now. I've been practicing family law for over 20 years in Texas, New York, and a little bit in Massachusetts.
Awesome. Well, today we have an interesting topic. We are going to be talking about court appointments in family law cases. And Patrick's got a lot to share about that. But before we get started, I want to remind everybody that if you want to schedule a virtual consultation, the information is below. You can call 866-DADS-LAW or visit cordellandcordell.com to schedule those virtual consultations. So Patrick, let's go ahead and get started. Why don't you tell us a little bit about court appointments in family law cases?
Sure. I think they're a great tool in a family law case. They don't fit every case, but in cases, and we're primarily talking about custody cases, not so much in property. There are professionals in property cases, but I'm focusing today on in custody cases. And I think they're a very good tool to use for different situations and different clients. They're very useful tools. They're good for both the client and to help the court. So as often as I can, I try to use one of these tools in a case.
So what are some of the court-appointed people that you can use in these cases?
Well, they range from, coordinators, more professionals in terms of mental health professionals like evaluators, other attorneys and or mental health professionals that act in roles representing the children or assisting the court. So there are different roles depending on what the need of the case is. So depending on the need and other factors like cost and timing, different roles fit different cases.
Okay, so you mentioned parenting coordinators. So if you're using a parenting coordinator in a family law case, first, what are some of the factors that you want to consider before you go ahead and use a parenting coordinator?
Well, they're really used, and I don't want to say a last resort, but they're used in very high conflict cases. Okay. So it's a situation where parents have a difficult time, whether it's during a divorce process or after a divorce process or any type of family litigation, maybe not divorce necessarily, but just when two parents split and they're still left with a job of co-parenting their child or their children. This is a professional that helps it sounds funny, but it's non-adversarial dispute resolution. It may be high conflict, but it's not adversarial. They're there really for the purpose of helping the parents work together to co-parent their children, providing resolutions to disputes, helping the parents focus on the best interest of the children, and helping the parents make decisions on many occasions. So that's a role that really is outside of the court process itself, but it's really meant to kind of help the parents together try to reach decisions and maybe co-parent in a more effective way.
So if the case is already over and they have disputes or issues, the parenting coordinator can help them resolve those instead of going back to court. Is that right?
Exactly. Right. And that can be used during a divorce or a contested case, just help the parents communicate, help them, really focus on the children, or after a case when they're still, okay, you have your decree, you have your order, but you still need some help working together as co-parents. And that's the role of the parent coordinator.
Okay. So in some states and some counties, I don't believe they have parenting coordinators. I do think it is somewhat state and county specific, but in your state, are those something that everybody gets, or do you have to apply for one?
You would apply for one. You can agree, and most of these appointments can be either court ordered in Texas and many jurisdictions, or the parties can agree to do that, like an independent contract. In Texas, we have both, coordinators and facilitators. And other states have other, statutory roles that are similar. But, you can agree, the court can order it, or the parties can agree to, hey, we need some help here, and let's work together with this professional to, act in the best interest of our children.
Okay. So before we even get to that, where we are already divorced and working through co-parenting with a parenting coordinator, sometimes people have to get there where we are trying to figure out who's going to have custody. So is there a person that you can use that would help to determine that?
Yes, there are different tools in that regard too. A very common tool used is a child custody evaluator. Some jurisdictions, they may be called social studies. In Texas, they're called child custody evaluations, but in New York, social studies or social investigations, where usually a mental health professional, but it can be a legal professional or other professional, but generally a mental health professional does an investigation and then interviews all the parties, gathers relevant records, and then ultimately makes a recommendation to the court in the form of a written report in terms of custody, possession, scheduling, rights and duties, of things of those nature. Generally not support matters, but usually, the different roles a parent would have, they make a recommendation to the court in those roles.
What kind of contact does this person have with the parents and the child?
Significant. I like the role of a child custody evaluator because they can do a deeper dive. They're not limited so much by the rules of evidence, which often happen in a court case. They can talk to the children, talk to the parents, talk to other involved parties, other professionals, doctors, teachers, and they have access to what would be hearsay in the normal course of litigation. They have access to information. They can talk directly to the child, where that may not be admissible in a court proceeding. That professional can then talk to a child, a parent, a third party, and have the benefit of that information to assist the court. This may be very beneficial to one of our clients because hearsay is inadmissible. Things that can't come in a trial can be used purposefully with a child custody evaluation. Also, the evaluator has easier access to a lot of information, whether police records, mental health records, doctor records. They have a lot of access to information more readily than a lawyer can.
Okay. Now that does sound sort of similar to a guardian ad litem role. Can you explain the difference between a child custody evaluator and a guardian ad litem?
Sure. A guardian ad litem can be a mental health professional, can also be a lawyer. They're more of a representative of the child. They're acting as the child's representative, where an evaluator is supposed to be more of an investigator or not tied to any one party. With a guardian ad litem or attorney ad litem is representing the interest of the child. So they can advocate for the child. They can also, obviously if the child's very young, there's some discretionary judgment that person can use. But their role is primarily focused on advocating for that individual, for that child, versus an investigatory reporting role to the court.
Okay. Are there any other court-appointed attorneys that would be there to help benefit the children?
Well, one role I know they have in Texas, which been using with some greater frequency now, is an amicus attorney. It's an attorney that doesn't represent any party. It's an attorney there to assist the court. So their role is somewhat similar to the a child custody evaluator, where they have access to the children, the parties, relevant third parties, school teachers. They can, by statute or by court order, have access to records. And again, they can really get to the heart of the matter pretty quick at a lesser expense than a child custody evaluation. And they can make a report to the court and assist the court in helping the parties, maybe in litigation, help the court with litigation to do what's in the child's best interest. In Texas, that individual cannot make a direct recommendation as to possession, custody, or access, but they can do a lot to bring issues to the court and help the court make those type of decisions.
What factors would you be looking at to determine if you should do an amicus attorney versus one of the other options?
Well, an amicus, I generally use those right away in a case because you may have a temporary orders hearing coming up. And if you get an amicus appointed, a lot of courts will allow that amicus, a couple limited amount of time to kind of get things up to speed for the court versus having a temporary orders hearing without a lot of information. The amicus can get on the case, do some legwork, do some investigation, and then really bring some issues before the court early on in the case. It helps get the case on track sooner versus, say, a child custody evaluation. For lack of a better term, it's more of an end product where you, through a whole process, an investigation, then the child custody evaluator or the social study evaluator, investigator comes in at the end and makes a recommendation to the court. This is kind of gets you a little help early on in the case. The role can go throughout the case, but it helps maybe right away get something moving in the case.
Okay. And so when we're talking about using these people to help determine custody, what kinds of things are they looking at? I mean, you mentioned how they've got access to all the evidence, they have lots of contact with the parents and the child. What are some other things that they're looking at?
Well, they look at, as you mentioned, they're talking to all the relevant parties in the case. Oftentimes, parties may be reluctant to talk to lawyers, may not want to come to court. So they'll do it like an investigation, talk to, again, teachers. If you want to drag a teacher or a doctor to court, they can get on the phone, talk to a professional, gain information, talk to family, relatives, play dates or play parents, parents of play dates. They can talk to those individuals and really gain information that's oftentimes hard to get in the course of litigation. And again, having access to records and ability to really, move with a little more quickness versus subpoenaing records or, doing depositions, or the litigation process can be slow and cumbersome sometimes, and it kind of expedites the process.
What about psychological evaluations? Are those done?
They can be done too. They can be ordered by the court. Now, in that case, it's more of a mental health, obviously, a mental health tool.
Right.
Don't make recommendations to custody or parental rights or duties, but they do an evaluation of a parent or a party seeking custody, and they can basically do the mental health work that gives the court information to assist the court in making hopefully a best interest determination in that case. Again, they don't make recommendations as to custody, but they'll do an evaluation of the party and get information before the court, which can assist the court in making those determinations.
Okay. Are there any other reports or processes that we use to get that information that helps the courts to decide about custody?
Well, there are other tools, yes. Again, it's not always in litigation, but they have like parenting coaches, very similar to a parenting coordinator or parenting facilitator. They work with parents together, trying to reach best interests of the children, help the people co-parent. There's also, in some jurisdictions, a child specialist that can be hired to assist parents and may go to mediation, and it's a very limited role in the mediation process where that person comes in and interviews the child and talks to the parties and helps at mediation to make that determination. And you often see a lot of other professionals, whether it's educational specialists or physical therapists or people in the medical field who help, whether it's a special needs child. Those people can be appointed or hired to assist, in, I'd say, not ordinary circumstances in different issues in terms of education, medical, or mental health issues.
Okay. So if someone does have a case like this where they have a highly contested custody issue, how do they know what resources are available to them and if they should do one, all, or none of these things?
Yeah, I'm not going to recommend them all in every case, but this is where you go. You talk to your legal counsel. In a difficult, if you say in a case you have bad facts and you may need, if you just go to court with bad facts, that could be a difficult case where a right professional may help, kind of ease those facts into the case. We're going to a hearing and the bad facts coming out. Say someone has a DUI, you go to court, the person has a DUI, it's a bad fact. But then they have their mental health professional can come in and step in and say, hey, this is what happened here. Kind of softens the blow sometimes of bad facts. But also, we're lawyers, we're legal professionals. And a lot of times, a lot of these issues involve mental health, more emotional, psychological issues. And that's what these people, a lot of these professionals, that's their arena of expertise. And they help both the lawyers, the parties, and the court in those cases.
How are these people retained? Is there a contract? Do they have to abide by certain rules?
Well, every case is different. Every state is different. Oftentimes, they can be appointed by the court, and the court can delegate or assign the financial responsibility between the parties, who pays for this, who pays for that, who's requested it. Maybe one party is more in need of the services. They can allocate it differently. People can agree to do this on their own without the court intervention or without court direction. When they contract for those professionals in a case, that can oftentimes save a client money versus extended litigation. A professional can get on the case, kind of get right to these issues, and while there's money up front, it could save money in the long run for a client.
Awesome. Well, that is all very helpful information. Thanks, Patrick, for sharing all of those things.
My pleasure.
Again, if you want to schedule a virtual consultation, contact us at 866-DADS-LAW or visit CordellCordell.com to schedule your virtual consultation. And thank you for joining us at the Men's Divorce Podcast.